The chair recognizes Mr. Turner in opposition to the bill.
Thank you, Mr. Speaker. Members, this was late last night when we heard this bill on second reading, and there was a lot going on. So I want to just spend a few minutes talking about what this bill does and why it's a problem. Let me be the first to say this is a reasonable debate for the legislature to engage in. It is reasonable for us to debate whether or not we want to give the Attorney General the power to prosecute election-related crime. That's a reasonable debate. But this bill is the wrong vehicle to do it with. It requires a constitutional amendment. If members want to give the AG this power, you need to amend the Constitution. And that is clearly the takeaway from the Stevens opinion. And contrary to the bill author's intent in his words, this bill does not comport with the Stevens decision. So the Stevens decision was in the Court of Criminal Appeals a couple of years ago, and the court essentially found that the Attorney General does not have the power under the Constitution to prosecute these crimes. And so I want to read to you a few excerpts from this opinion. The Constitution of 1876, which our state still operates under, expressly divides the powers of government into three distinct departments, legislative, executive, and judicial, and prohibits the exercise of any power, quote, properly attached to either of the others, unless that power is grounded in constitutional provisions. The separation of powers provision reflects a belief on the part of those who drafted and adopted our state constitution that one of the greatest threats to liberty is the accumulation of excessive power in a single branch of government. The Texas Constitution contains this explicit separation of powers provision, unlike the federal Constitution, which contains no express separation of powers provision. Instead, separation of powers is implied through the federal Constitution's structure dividing government into three branches. We have previously held that this textual difference between the U.S. and Texas Constitution suggests Texas would, quote, more aggressively enforce separation of powers between its governmental branches than would the federal government. So think about that for a second. This court has held that the way the Texas Constitution is drafted is that it is more aggressive, more serious about protecting those separation of powers than even the federal Constitution, where those separation of powers is very, very well established. The court continues. As previously discussed, the enumerated duties of the Attorney General as specified by the Constitution are limited to inquiring into charter rights of private corporations, suing in state court to prevent private corporations from exercising powers not authorized by law, seeking judicial forfeiture of charters, and providing legal advice to the governor and other executive officers. Notably absent from these enumerations is a specific grant of authority to the Attorney General concerning the prosecution of criminal proceedings. Undeterred by this omission, the Court of Appeals applied an expansive interpretation, holding that because the AG may act on behalf of the state against corporations, and because corporations, like elections and elected officials, are wholly creatures of state actions, it follows that the Attorney General has authority to prosecute. This is a misapplication of the doctrine. The Court of Appeals disregarded the doctrine's fundamental point that, quote, the principle warns against the expansive interpretation of broad language that immediately follows narrow and specific terms and counsels us to construe the broad in light of the narrow. Further, the Constitution already grants this authority to county and district attorneys, as we discussed yesterday on second reading. Because this is already the specific duty of county and district attorneys, the Court of Appeals erred by misconstruing the other duties clause to encompass judicial branch duties. To elucidate the absurd results that such an interpretation of other duties would render, Stevens notes that the Constitution also permits the legislature to assign the Secretary of State and the Texas Water Development Board other duties, to assign notaries public such duties as prescribed by law, to assign duties to county clerks and sheriffs, The court says, if we were to adopt the reasoning of the court below, then the legislature could grant the Water Development Board with prosecutorial authority. Perhaps this example is extreme, but it certainly emphasizes how relying on other duties would render meaningless the separation of powers. Absent the consent and deputization order of a local prosecutor or the request of a district or county attorney for assistance, the Attorney General has no authority to independently prosecute criminal cases in trial court. Therefore, while there are some overlapping duties, the Constitution specifically separates the power of the branches. Any attempt to overlap the Attorney General's constitutional duties with county and district attorneys' constitutional duties in the sense of a Venn diagram of sorts is unconstitutional. Practically speaking, any overlap is necessarily invitational, consensual, and by request. A county or district attorney must request the assistance of the Attorney General. Under the current Constitution, overlap of the duties of the Attorney General and those DAs and county attorneys occurs, if at all, on a case-by-case basis. So, members, the court was very clear about this. It was unconstitutional what the AG was doing before. Passing this bill will not make it constitutional. It will require a constitutional amendment, which we do not have before us today. And the question, members, really is this: do we care about the rule of law or not? Does the Constitution of this state matter or not? The Constitution is designed to protect the people, to protect all of us, protect our rights, regardless of who is in power at any given moment. The Constitution is the sturdy, resilient infrastructure of our republic, nationally and in Texas.
Mr. Speaker.
Members, please take your conversations outside the rail. Ms. Jones, for what purpose?
Will the gentleman yield?
I'll be happy to yield in just a moment.
Not at this time.
The Constitution is the sturdy and resilient infrastructure of our republic. Much like a reinforced building that can withstand an earthquake or a hurricane, the Constitution protects us regardless of what's happening in the moment, the politics of the moment, and who is in power. Members, we have not always had a Republican Attorney General, and we will not always have a Republican Attorney General. So before you grant expansive new powers to the Attorney General in violation of the Constitution, I hope you'll think long and hard about the long-term implications of doing that. I'll be happy to yield for questions.
Ms. Jones, for what purpose?
Will the gentleman yield?
Will the gentleman yield for questions?
Yes, I do.
The gentleman yields.
So, gentlemen, Ms. T walked back here and reminded me of something, and she is a lawyer.
Yes, she is.
And so here's the question. Does this bill 5138 limit the AG to a certain time period to sue? Did you see that anywhere?
Not that I've seen.
So
no.
there's a time limit for local prosecutors who are
Yes, sir.
elected by the people that live there, but the AG has unfettered discretion of when to bring a lawsuit, correct?
That's absolutely right. And to expand on your point, your question, county and district attorneys, local prosecutors have a constitutional responsibility and a constitutional duty to prosecute these crimes. The Attorney General does not. Why would we limit them but not limit the Attorney General when that office doesn't even have the power?
And then also, so when we heard the author of this bill talk about, oh, we're going to pass another law that lets the AG do what the Constitution prohibits, we believe it then becomes constitutional because we give them 6 months. So in other words, time limits it.
Yeah.
Now, do you see, like I see, and like blind people should see, that the Constitution is the Constitution? If it says that prosecution of criminal cases, especially in the election arena, since State v. Stevens related to election-related incidences, that this doesn't cure the Constitution problem.
That's absolutely right, Representative Jones. That's my point. I heard the bill author say those things. That has nothing to do with the fundamental constitutional problem, and that's why this bill is fatally flawed. It is unconstitutional on its face.
And I will say this, would this not be a perfect example of why there's a separation of powers? You got a legislative body that wants a law like it wants, and it's like, I be damned with the Constitution. They pass the law, as the rules of the legislature require, goes to the Senate, the governor can sign it, and then the judicial branch, which is another branch of government, gets to come and strike it down by the Court of Criminal Appeals and say, hey, legislature, no, 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 no. That's against the Constitution.
Gentleman's time has expired.
Correct? I won't ask for an extension. Thank you. You answered my question.
Mr. Speaker,
Mr. Boosie, for what purpose?
I request motion to extend the time.
Members, you've heard the motion. Is there objection? Chair hears none. The gentleman's time is extended.
Mr. Speaker,
Mr. Busey, for what purpose?
will the gentleman yield
Will the
for
gentleman
questions?
yield for questions?
Yes.
The gentleman yields.
Thank you, Representative. I was listening intently to your layout and to your exchange with Representative Jones. I thought it was very important. I thought y'all made great points, but if you would, my question is, would you look around the room at our colleagues real quick and notice that I don't think many of them are listening to this exchange of one of the biggest bills. So, Mr. Speaker, can we get some order in the room?
Members, please take your conversations outside the rails.
This is a bill which I think you laid out really well in your opposition to why we need to oppose this. Unfortunately, our colleagues were chatting about everything else under the sun while you were talking about a bill that deals with the separation of powers. Haven't we done this before? Have we gone down this path before in this body?
Well, we have, Representative Busey, and you know, this is an issue that's been much discussed over many years, and I think you've been a leader in exposing some of the fallacies behind some of these supposed voter fraud investigations that the Attorney General's office has undertaken, which ultimately led in part to this lawsuit that made it all the way to our state's highest criminal court, the Court of Criminal Appeals, and the court, it wasn't even a close call. If you read this decision, it's not even a close call. The Attorney General has no authority under our Constitution to prosecute these crimes. That power rests solely and exclusively with local prosecutors, DAs, and county attorneys.
And so when you in your opposition speech, you started by saying, this is a debate that is worthy of this body, but this is not the way to debate this. One, by not paying attention and the disrespect that you're getting from your colleagues, but two, because the courts have ruled very plain and clear that we do not have the authority to do this unless we do it through a constitutional amendment. Wouldn't that be correct?
That's absolutely right. And this really comes down to, do we care about what the Constitution says or not?
Well,
if we don't care, I guess it's okay to pass this bill. But I do care, and I think you care, and I hope a majority of this body cares that what the Constitution says matters.
The majority of this body I've heard over and over say they're strict constitutionalists. Yet, again, we are throwing the finger to the face of the courts right now who have said, we underscore in the majority opinion that we do not have this authority to override the Constitution simply through a bill. We've done this before. We've had this go to the courts. They've overridden us. They said, don't do it this way. This body had the option to bring a constitutional amendment, did they not, on this matter?
Absolutely, and I asked Representative Shaheen that question when we heard this bill in the State Affairs Committee. Why is this not a constitutional amendment?
So the conservative court has said, if we do this, we'd be making the same mistake we've done before. We are violating the Constitution if we do this.
Well, that's exactly right, and this is going to lead to more costly litigation that ties up the Attorney General's office, ties up the Court of Criminal Appeals, and lower courts. Why would we do that?
So we have a lot of fiscal conservatives on this floor. If they vote for this bill, they know just by reading the opinion and recent history that they will be violating the Constitution, they will cost taxpayers tons of money, and they will be doing it to end up in the same place we are today, not having a proper debate, but one that we could have had through a constitutional amendment. Is that correct?
That's exactly right.
The court said, we don't have this right. We're going about this wrong. If we want to have this debate, if we want to continue to give away powers that we're doing this session of the Attorney General, this is absolutely wrong. It's fiscally irresponsible. It's a violation of the Texas Constitution. Thank you for your opposition. Let's vote no on this bad bill.
Thank you, Representative Busey.
Mr. Speaker.
Ms. Gervin Hawkins, for what
Will the
purpose?
gentleman yield for
The
questions?
gentleman yield for questions.
Of course.
The gentleman yields.
Representative Turner, I'm not an attorney.
Nor am I.
But when I've heard this discussion, and I think the greatest level of concern is doing unconstitutional things in a body such as this. So my concern is that as our members are making these decisions
no doubt, obviously, the responses have already been generated. Would you agree with that? In terms of not listening, in terms of not understanding, and making good policy. Would you agree with that?
Well, it seems sadly that is the case. That's why one of the reasons I wanted to come up here this morning, Representative Gervin Hawkins, is because this bill was taken up on second reading late last night after it had been a long day, and I know people were tired and distracted with other things. So I really want to use this moment on third reading to draw some attention to the seriousness of this bill and how seriously flawed it is and how patently unconstitutional it is. All anyone has to do is read this court decision or listen to the excerpts that I just read from the court decision to know it is unconstitutional. And if members feel strongly that the AG really needs to have this power, then the proper way to do that is to file a House joint resolution so there would be a constitutional amendment on the ballot for the voters to decide if they want to amend the Constitution to give the Attorney General this power. That's the proper way to do this.
And the other thing that I'm concerned about when I hear, because we know a lot of our DA offices are short-staffed.
Sure.
So when you put a 6-month time limit on a local DA's office, we put more pressure on, additional pressure on them. Would you agree with that?
Absolutely, absolutely. And I don't think it's the job of the legislature to micromanage how our local prosecutors are going about their jobs. They've got a lot of things to balance, and so they're investigating and prosecuting violent crimes, murders, a host of other things. And so they've got to balance all that with the priorities of their local community in mind. Why would we try to micromanage them and put some artificial timeline on them and then say, we're going to take this away from you and give it to the Attorney General, unconstitutionally, I would add, because you don't get it done in 6 months. That's unrealistic and unfair.
So it's, realistic is a slap in the face to the local DAs. Would you agree with that?
Absolutely. And I hear a lot, you and I both hear a lot about how we support local prosecutors. This is not the way to support our local prosecutors. Our local prosecutors need to be empowered and respected, not have their constitutional authority whittled away through an unconstitutional bill.
And Representative Turner, if we give so much power, because I'm hearing every bill is going to be resolved through the Attorney General, aren't we also putting that additional burden on the Attorney General's office that is so humongous that we will end up in trouble doing things that we need to do that's most important?
Look, absolutely. I think the Attorney General's office, again, irrespective of who is in the top office in that agency, needs to be focused primarily on child support enforcement in our state, consumer fraud, and enforcing our consumer protection laws. Those are two of the most important functions of the AG, and I really like the focus of that agency to stay there because our constituents need that help.
And not on what the local Attorney General should do. So, you know, when we talk about our various municipalities and areas where our DAs are, right?
Sure.
So we're literally saying we're going to, after 6 months, if you haven't litigated this, we're going to take that from you. And so wouldn't that delay cases?
I think it well could. I think it well could delay, create unnecessary delays and costly delays that again, there's no reason for us to do.
And not only that, the big thought that I have too is the DA is so separated from the local community, I mean, not the DA, I'm sorry, the Attorney General, that they don't really even know what's going on in that locale.
Well, absolutely. I mean, the Attorney General's office has 254 counties that they have responsibility to, again, in primary responsibilities such as child support enforcement, consumer protection. I don't know realistically how the Attorney General can take again, irrespective of who's in the office, how that agency could take on this responsibility that is envisioned in this bill, again, in violation of the Constitution.
So our members really need to think twice before they dump a whole new basket into the Attorney General's lap and say, we hope you can resolve it.
I agree, and I hope members will vote no on this bill for those reasons.
Thank you, Representative Turner, and thank you for bringing it to the light of how this is troubling across the board, no matter what party you in. No matter what party,
That's right.
It is troubling.
That's right.
Thank you, sir.
Thank you, Representative. Members, I ask you vote no on this bill.
The chair recognizes Ms. Johnson to speak against the bill.